everybody. Welcome to Thursday. Today is the 16th of November. My name is Sam Goren, spelled G-O-R-E-N. I'm the special magistrate in today's proceedings. We are here today to speak about the case referenced as 961A1A LLC and 997A1A LLC as petitioners versus the town of Jupiter as a respondent. Why am I here? I've been asked by the parties to be the special magistrate in this proceeding. This is a very unique part of Florida law, just FYI. I'm a lawyer. I've been a lawyer for 48 years. My law firm represents local government. I represent a regional planning council in South Florida. To the extent that the proceedings are unique, let me tell you exactly why. The statute that we're operating under, for the record, is referred to as the Florida Land Use and Environmental Dispute Resolution Act, better known in the common practice as FLUEDRA. It was chosen by the petitioners to facilitate a review of their claims and to provide a forum in which we can have this discussion today and to try to resolve the matter if at all legally possible. Under the statute, as a special magistrate, and I've been a magistrate in many matters in the past, as I said to you before, I represent several local governments in Broward County. We represent cities in Palm Beach County as well. The magistrate, for the definitional side, means a person selected by the parties, which means that I didn't select me, they selected me. There's no accident as to why I'm here. To perform the duties prescribed in the section, the special magistrate must be a resident of the state, which I am. I've been here since the mid-70s, and possess experience and expertise in mediation. I've been a certified mediator for 30 years, Supreme Court mediator, and at least one of the following disciplines, and a working familiarity with the others: land use and environmental permitting, land planning, land economics, local and state government organization and powers, and the laws governing the same. So, from the standpoint of why I was selected, it was because I have this expertise, just for the record. Now, I know the lawyers involved in this case, and I want you to know that up front. We don't have any conflicts, which were cleared well before I was hired to serve in this capacity. Tom Baird used to be a lawyer in my law firm probably 20 years ago, maybe more. When he actually had a full head of hair back then. But at the end of the day, the end result of which is that Tom was a lawyer in our office, but it was a long time. I can't even tell you how long ago it was. I know Howard Nelson because Howard Nelson used to be a planner before he became a lawyer at the South Florida Regional Planning Council, which has been a client of mine and my law firm for 40 plus years. So we have an experiential relationship together, so I know them. That doesn't mean that I would favor anything that they would say or do, but from the standpoint of being in this room today, I want you to know for the record that I do know who they are. So what's the process going to be today? The process and the rules of the road would be very simple, but I want you to understand exactly how it's going to work, because the statute empowers me to make certain decisions to make sure that we maintain civility, we maintain the ability for you as members of the public to be heard, and to be able to deliberate appropriately. In that regard, this is a unique provision of Florida law. This is the public session at which you will be given a chance to be heard. It will be on the record, it will be recorded. The clerk will certainly have your cards, and we'll be able to know who you are. The lawyers at some point will make an opening and a closing statement, for sure. Probably had to do that before the public comments, just to lay the groundwork for the presentation. But part of the process, when I want to be very clear about this, includes the word mediation. Mediation. The statute tells us that in all respects, the hearing must be informal and open to the public, which it is. Those doors aren't locked, as I checked, and does not require the use of an attorney. The hearing must operate at the direction and under the supervision and of the special magistrate. The object of the hearing is to focus attention on the impact of the governmental action giving rise to the request for relief, and to explore alternatives to the development order or enforcement action and other regulatory efforts by the governmental entities in order to recommend relief and, when appropriate, to the owner. The first responsibility of the special magistrate is to facilitate a resolution of the conflict between the owner and the governmental entities, to the end that some modification of the owner's proposed use of the property, or adjustment in the development order, or enforcement action, or regulatory efforts by one or more of the governmental parties may be reached. Accordingly, and this is directly from the statute, the special magistrate shall act as a facilitator or mediator between the parties in an effort to effect a mutually acceptable solution. The parties shall be represented at the mediation by persons with authority to bind their respective parties to a solution or by persons with authority to recommend a solution directly to the persons with authority to bind their respective parties to a solution. What does that mean? What that means is that after we provide the opening statements of both the city, the town, as well as the property owner, we're gonna have you make your presentations. There are apparently 8 speakers this morning, and we're gonna give you at least 5 minutes to make your presentation. If you need to go a little longer, we can coordinate that for discussion as well. I wanna make sure you're given some time. Once the public comments are concluded, the statute contemplates mediation and requires privacy with regard to mediation. So what's gonna happen is, and I don't wanna bore you with the details, but once you finalize your public comments, we're gonna break into what's called private sessions. This is the public session, where the public has a right to be here. But at some point in time, we're gonna go to another part of this building, and I'm gonna meet with both the town and the property owner in separate rooms, not together. And I will be sort of a concierge going between both rooms, discussing what options and discussions we can have regarding, as the statute requires, potential resolution of the controversies before me and before the town as well. Those are private sessions. They're not recorded. The public has no right of access. In fact, what I discuss with any one party in one room is not discussed with the parties in the other room, only unless the parties in one room authorize me to do so. The mediation process is part and parcel of the statute, not just talks about, but requires. At some point in time, hopefully, at some point in time today, we will be able to announce where we are with the status of the case after visiting with both parties during today's presentation. The other part of the matter which is important to note is that there will be some downtime for you. I can't assure you that I'm going to be with one party for 5 minutes or 5 hours. I don't know that. I won't know that till I actually get into the room with both parties. They may say, you know, this is the deal, we're not going to do anything differently or further, and we're not going to talk about it. That's not the process. The folks in this room chose this process. The owners of this property chose this process. And by the way, I've looked at the record. I've seen the documents. The lawyers were required to send those things to me, which I've read, and I've digested them. I'm aware of the issues and I'm aware of the controversy. So why am I here? Well, I'm here because I was selected as a magistrate. I could be someplace else today. I could be in my own private office. I've been in there for 3 days. I had city commission meetings on Tuesday night and Wednesday night. And to that extent, my experiential background suggests that I sit typically at the end of the dais in other locations, but today I'm here in a different capacity. Just because I work for the government or have a predominant governmental practice does not mean I'm biased towards anybody. I have a significant number of private clients as well. We represent private owners in our law firm. Our law firm is not 50 or 100 lawyers. We're 13 lawyers. All of my law partners are city attorneys somewhere. We represent special districts. We represent region planning councils. And we represent all folks in between. So there's a great deal of familiarity between me and the process. Anybody have any questions? What I'd like to do, and thank you by the way for being here. I appreciate the fact you made time today to do this. It's a Thursday, and people typically work, if not, if they're retired, but whatever your schedules are as a lawyer, sitting in this room, sitting mostly with public clients, I appreciate the fact that you made use of your time to be here. As important as it may be to the people sitting to my right, it's important to you as well, and I recognize that. And this statute not just recognizes that, but dignifies it as well. So your comments will matter. They're going to be recorded. The clerk actually has, we're being recorded now, and maybe even live streamed, I don't know, but to that extent, the record will be the record. What I'd like to do is, again, I've announced the case. The town properly noticed this proceeding on October the 23rd. It was posted and published to the extent possible, and we have that on the town's website, and to that extent, it's been properly noticed in accordance with state law. What I'd like to do is have opening statement from both parties. I assume for discussion, we'll hear from the petitioner first. 10 minutes plus or minus, or even more would be fine. And by the way, if you see me taking notes when people are speaking, that's okay. If you don't see me taking notes while people are speaking, that's okay too. Because at the end of the day, I'm more mature than I used to be, and I don't remember as much as I'd like to, so from that perspective, I typically would take some notes. Yes,
Can I just get clarification? I was under the impression you were just going to both make presentations?
Yes, yes.
Okay, so opening statement is the presentation?
Just presentation.
Thank you.
And just for the record, I've had some pre-hearing conferences with both sets of lawyers. And to that extent, we've done everything we can to tailor the process today to the facilities that are provided for in this building and also in the statute. So, thank you for that. Yes, ma'am.
Thank you. For the record, Leanna Kozlowski with the law offices of Bills and Sumberg, 1450 Brickell Avenue, Miami, Florida. I'm joined this morning by my colleagues Howard Nelson and Philippe Jeck, and together we represent the property owners 961A1A LLC and 997A1A LLC. We will also be joined later this morning by the owner representatives Charles Modica and Ben Brown. The introduction that Mr. Gorin gave was very comprehensive, so I won't spend much time on that, but by way of background for the folks here this morning, this is a fluidric proceeding concerning about 10.5 acres of waterfront property located approximately at the northeast corner of Clemens Street and North A1A along the south side of the Loxahatchee River. This is the former site of the Sunny Sands Mobile Home Park, and it is predominantly zoned high-density residential use with a small portion allowing for general commercial use. The owner did in fact initiate these proceedings, and it was in direct response to a July 25th, 2023 development order issued by the town council in connection with the owner's application for a certificate to dig permit. Through that development order, the town imposed several restrictions on the development of the property that for all intents and purposes leave it in an undevelopable state. The restrictions go well beyond the recommendations of town staff, and they conflict with the findings of several archaeologists who studied this property extensively for close to a 10-year period. To the members of the public who are here this morning, to our special magistrate, and to the town officials who are here as well, I want to make it clear that this is not a case where we have a developer who did not do his homework. In fact, it's quite the opposite. Mr. Modica has been a resident of the town for 30 years. His family is here, his businesses are here. He is deeply invested in this community, and that is why he poured significant resources into fully understanding the historical significance of this site and assembling what is the best archaeological team to ensure the appropriate scope of preservation. I do want to spend some time outlining those efforts because it's an important component to this proceeding. So first, before even acquiring the property 10 years ago, the owner engaged in substantial due diligence. Part of that was reviewing the town's map of archaeological sites and zones. That map specifically identifies the property being in a moderate potential archaeological zone, not high potential archaeological zone, moderate. And that zone does not prohibit development, it simply requires development to be subject to archaeological review. Again, going back to the efforts on the due diligence side, the owner reviewed the Florida Master File sites for both the Sunny Sands Shell Midden and the Celestial Railroad. With respect to the railroad, the Florida Division of Historical Resources does not even identify the railway as an archaeological site. And this is important. With respect to the Shell Midden, the state only recommends that the mounded part of the midden be preserved. Not the entire 10-acre property, not even the entire 4.07 acre midden site. We are talking about the mounded portion of the 1.47 acre principal mound. The owner also went directly to the town and obtained a zoning verification letter back in 2013 from the Department of Zoning. And in response to the owner's questions about the property's zoning and what the scope of permitted development could be, the town never mentioned once an archaeological or historic site.
Never mentioned any restrictions on development. To the contrary, the Department of Zoning confirmed that the 9.86 acre parcel, one of two parcels that comprise the site, could be developed consistent with the high-density residential and Riverwalk Flex land use designations. So, relying on the town maps, the comprehensive plan, the land development regulations, and the facts from the state and from town staff, the owner acquired the property, terminated that mobile home park, and assembled a team of preeminent archaeologists. That includes Bob Carr, who is Dade County's first county archaeologist. Mr. Carr performed hundreds of excavation tests throughout the property over a 9-year period. The team also included Timothy Parsons, the former director of Florida's Division of Historical Resources. And what Mr. Parsons did was essentially perform a peer review of Mr. Carr's work, and he said, I agree with these recommendations, I agree with these conclusions. So after all of this testing, the results from all of these excavations essentially reveal that we've got intact midden, mostly around the 1.47 acre principal mound, and disturbed midden throughout the remainder of that midden. The team never found a burial site. The team did not find a graveyard. They found a textbook definition of a shell midden on the 1.47 acre portion of the property. The only human remains found were 7 non-fossilized teeth and 1 non-fossilized patella. All of this reporting is public information, and as Mr. Gorin said, it is in fact in the record below. Relying on the information from the experts, the property owner submitted its application for a certificate to dig and was proposing a preservation area of 2.09 acres. That's already 20% of the property. It includes the 1.47 acre principal mound, an adjacent historic staircase, and about 2.1 acres of the Celestial Railway right-of-way, which the owner was agreeing to not build on top of. In addition, there is a Phase 3 management plan, and it requires 1, painstaking archaeological excavation and recovery of any prehistoric artifacts or materials found within the remainder of the 4.07 acre midden site. And it also requires archaeological monitoring of any subsurface ground disturbing activities on the 9.84 acre site. Notwithstanding all of this competent, substantial evidence, the town's Historic Resources Board, back in March, denied the certificate to dig and determined that the entire property needed to be preserved. The order, which was not supported by the town's staff recommendation or the town's archaeologists, was overturned by the council in July. But the council's decision is still a departure from the essential requirements of law because the conditions that were ultimately imposed on the property owner go well beyond the town's charge of imposing conditions that, quote, are deemed necessary to protect archaeological resources of significant value. Through that order, the town council more than doubled the preservation area. We went from 2.09 acres to 4.07 acres, plus that 10-foot buffer. The order then restricted digging on the Celestial Railroad right-of-way, which, by the way, bisects the entire property, and restricted any development that would impede on the view corridor from the north of the Celestial Railway to the river. So, after almost a decade of studying the site, assembling one of the most respected archaeological teams, and working very closely with staff to create a development plan that would in fact preserve the significant cultural resources on this property, the town is now saying to us for the first time
that about 50% of the property, private property, must be preserved. And when you factor in the practical implications of the zoning regulations, that number is more like 62% of the property that can no longer be developed. I'm wrapping up, if I could just have another 30 seconds, thank you. So what the property owner is left with is multiple awkwardly shaped, narrow, non-waterfront portions of a property that doesn't come close to resembling the highly developable waterfront property acquired in 2013. There is no clear legal basis to restrict the owner's certificate to dig beyond that 1.47 acre mound. And the owner's decision to purchase this property for about $17 million was based on reasonable investment-backed expectations that this property could be further developed with at least high-density residential project in accordance with the existing future land use and zoning designations. This development order essentially leaves Mr. Modica with less than 4 acres of a 10.43 acre property. It's in conflict with the land development regulations that apply to this site. It goes against the recommendations of multiple respected archaeological experts. It goes against the recommendations of town's own staff, and frankly, it's exactly the sort of unreasonable and unfair burden on property rights that Chapter 70 of the Florida statutes protects against. We are hopeful, though, that through these proceedings, we will be able to work with the town to agree upon a preservation boundary that is in keeping with the record evidence and appropriately respects the significant archaeological areas of this property without inordinately burdening this owner's private property rights. Thank you.
Thank you very much, Councilor. Baird? As you approach the podium, anyone who has not yet signed in and would choose to speak this morning, please do. We will, please, clerk, provide your name and address and other information that will go into the public record. If you choose to speak today, please sign up so I know you are. And the record knows who you are as well. Thank you. And by the way, for the record, if I call Mr. Baird or Tom, it's only because of familiarity. If I call Mr. Nelson Howard, it's because I know these folks and have worked with them for years. The objective here is to get every information we can on the record for public consumption and for review in accordance with the statute.
May it please the court, Your Honor.
Yes, sir. Proceed.
All of this property is worthy of preservation based upon its archaeological and historical significance to the town. The vacant property, because of its size and location on the Jupiter Inlet, is within a real estate market with property values that are extraordinary. That has to be acknowledged. Even with adjustments made by appraisers who value this property, the property will still retain some value based upon the zoning entitlements that it currently has. Those zoning entitlements are protected by the United States and Florida Constitution and by the laws of the state of Florida, including the Burke-Harris Act. The laws that protect these property owners and obligate the town council to act within them are separate, and they are distinct to the United States, and they differ from other countries who do not recognize the need to balance property rights with the rights to preserve and protect land. The council's dilemma when faced with these competing forces was to make a decision to balance the rights of the property owner and the rights of the public, as well as the indigenous people who had previously resided there and whose cultures remain there. In their hearts, council members certainly wanted to preserve the entire property, but that's not what their order states. And the economic reality of it is that the council has to balance the overall competing forces and funding requests for its population in the town with this single piece of property. But what the council did do was decide to protect the property that is recognized in the Florida Master Site File as having significant and archaeological and historical value, and to impose conditions on the balance of the property which would ensure that the resources that might be uncovered there are also protected. This is the best approach to protecting the heritage and cultural artifacts of that property. And that is the reality of the council's decision. There was substantial competent evidence presented to the Historic Research Board, which was then furthered and forwarded to the town council for its decision-making. Among the evidence were the opinions of 4 archaeologists, each of whom examined the property in years 2015, 2017, 2021, and 2022. The 2 sites are the Sunny Sands Shell Midden and the Celestial Railway. The petitioner has represented that its very respected archaeologist, Bob Carr, which the town acknowledges and which I acknowledge, is one of Florida's most prominent and renowned archaeologists. Here's what Mr. Carr had to say about this property. And he was referring to the other archaeologists with whom he collaborated in evaluating the property. We are all in agreement that this is an incredible site. Why is it an incredible site? Because, number one, it's the historic site as the beginnings of modern Jupiter. The Celestial Railway terminus is on the south side of the Jupiter Inlet. This is where the first downtown of Jupiter emerged, and it needs to be preserved because it is the history of the beginning of Jupiter. A lot of the testimony that was presented came from Brian Davis, who is the Palm Beach County's archaeological and historical planner and expert. His comments were to the effect of, the area of the Celestial Railway was the foundation of the town. The unique confluence of the Jupiter Inlet, Loxahatchee River, and Indian River provided a landing point for the transportation not only of goods south into Palm Beach County, but also settlers south. The area along the inlet where the railway dock existed, in which the council has said should be preserved, played a pivotal role in the establishment of Jupiter and Palm Beach County, because settlers continued and commerce continued south from that point into South Florida. So consider what we have now in South Florida. It started with this little terminus. We now have the 3 most populous counties in Florida: Palm Beach, Broward, and Dade. Is it all attributed to this one site? No. But is it historical in that context? Yes. There's also the Midden. Its use and this area's use by indigenous people dates back 6,000 years. Carr's initial investigation of the property confirms it was used as a residential property and portions were used for rituals after fishing. Some of the documented archaeological resources were by Mr. Carr were hundreds of bones, lithics, and other cultural materials, articulated shark vertebrae, monk seal teeth, very rare, greenstone hammer, carbonized botanical and animal remains that illustrate the diet of indigenous people, 7 human teeth, and one patella. In his phase 3 management study, he did 23 tests. He documented 3,500 pieces of prehistoric ceramics, 1,300 shards of prehistoric ceramics, 4,800 pieces of prehistoric ceramics. In addition to the archaeological evidence of habitation, he articulated that this was evidence of a deliberate burial ground of articulated sharp vertebrae, evidencing some type of ritual offering. This is a historic archaeological site to our Native Americans. Robert Rosa, the American Indian movement, testified. He requested the preservation of the 4-acre midden. Betty Osceola, president of the Southern Nation of the Miccosukee, members of the Panther Clan, testified and requested preservation of the 4 acres. She testified that based on the Miccosukee culture, the property probably contained human remains. This is the evidence that was before the historic board and eventually the council. So what about the due diligence work that the property owner did prior to acquiring the property and after acquiring the property? What was known at that time was, amongst the things that were known, was the existence of a boathouse, which was a historical feature of the Sperry property, the footprint of the Celestial Railway, a historical staircase that led to the meeting room, which was the top floor of the Sperry boathouse, the midden, and there was a listing of the 2 sites on the master site file. One can quibble about whether they're moderate or substantial, but the evidence suggests that it's substantial. The information that was in the owner's possession at that time should have at least tempered the investment-backed expectations. And the owner was on notice that this was a significant site. We haven't heard any type of presentation, nor was any presented at the hearing about the owner's understanding of the significance of this property to the history of the town of Jupiter. The focus was entirely on the archaeological site. This owner has a history of some overly ambitious development plans in the town. And by the way, the owner lives in Jupiter Island, not the town of Jupiter.
Yeah.
The same principle of the 2 LLCs that are before you today proposed an overly ambitious development plan known as the Love Street project. There was significant public opposition to that project. I'm going to need more time. The project was approved on a 3-2 vote, and later that ambitious plan was ratcheted back. It was still controversial, but it was again approved. So today's council is a lot more conservative in its approach to managing the growth of the town than the council that approved the Love Street project. Nevertheless, the owner, perhaps not learning from the lessons previously rendered, came in with a development plan that accompanied this certificate to dig that was overly ambitious and could only be realized if the following changes were made to the town's planning and zoning documents. Changes to the comprehensive plan, changes to zoning, granting of special exception uses, the creation of a PUD, planned unit development. These changes were all necessary to accommodate that ambitious development plan. And I know, Your Honor, from your experience in representing many municipalities, understands the difficulty of reaching decisions to change comprehensive plans, change zoning codes, approve planned unit developments. So what was proposed for this 10-acre site? 72 dwelling units, 1,200 square feet of restaurant retail uses, and a 125-room hotel. The owner's justification for cramming these uses in the area of 2 known archaeological sites was this: The property is prime for this kind of development, given its location on the Loxahatchee River, just minutes from the beach, and its continuity to residential neighborhoods. The proposed inn is meant to be contextual to the history of the property. What does that mean? That you can have a hotel that is in context with an archaeological site? I don't know. The proposed architecture was inspired by the historic architecture of the town. Well, you would have to travel west of this area and see the houses in the town to have a true understanding of the architecture of the town of Jupiter, because most of the significant buildings that have been constructed in this town occurred long after anything could be called historic other than residential properties. Went on to say that included the Jupiter Lighthouse. So we're gonna have architecture that's consistent with the Jupiter Lighthouse. And then thrown in there was the Sunny Sands Boathouse, which has since been torn down. This justification underscores the owner's failure to grasp the archaeological significance of this property and its historical importance to the town of Jupiter. A hotel in the inlet village and architecture reminiscent of the Jupiter Lighthouse and Sperry Boathouse may feel good, may even sound good to some, but this is window dressing and does little to preserve the property's archaeological and historical significance to the town. So one of the big issues here is, moving forward, the development of the site and its consistency with the comprehensive plan. Any approved development order and the certificate of dig is at best a preliminary development order because it only authorizes the development of some portion of the site, has to be consistent with the comprehensive plan's policies. Now, the future land use element of the comprehensive plan references this property as a significant historical site meriting protection. I don't think you heard in the presentation of the owner's due diligence any reference to the comprehensive plan and what had been done in terms of recognizing how the comprehensive plan, which courts have likened to a constitution, how that property was treated. The plan also has a policy that states that it is the town's policy to pursue local historic designations or other protective measures for the property. These policies are to fulfill the public interest adopted by the town's comprehensive plan. The certificate to dig accomplishes that. So does the certificate to dig create an inordinate burden? No. The owner's request is the magistrate find an inordinate burden because they've asked or they've stated that they want to retain what they believe were their rights to a highly developable property that the owner acquired for $17 million. As noted, in Florida at least, there's no guarantee to the development of property at its highest and best use. There's only a guarantee that one can develop its property consistent with a comprehensive plan and consistent with the zoning codes of the local jurisdiction that has the ability to review the plan, review the development proposal. Fact is, no development order has yet been rendered, and we don't know what might be developed on that site. While the certificate to dig is a development permit, it grants the owner essentially the opportunity to develop more than 60% of the site while preserving the properties that are listed on the Florida Master Site File. That's significant, and it's also significant that although you heard that this site is chopped up into pieces that render it undevelopable, when you look at the site, you see that there are large swaths of land, including approximately 5 acres of land that fronts on A1A, all of which, under the council's CTD, could be developed subject to monitoring of the site and careful analysis of any artifacts or other resources uncovered on the site. I stated it's a long-standing principle of law, and Your Honor knows this, that a property owner is not entitled to the highest and best use of his property. Hillsborough County versus Ralston. But the owner's investment-backed expectations are based on its own assumption and belief that the town council should approve all of the applications it submitted. I heard several references to the staff, that this was not consistent with the staff's recommendation, that it was somehow the expectation that the town staff is now making policy decisions for the Jupiter Town Council. That has never been the case and never will be the case. The staff has its role to play, as you know. They make their best judgments, but in the end, it is elected officials who decide what's best for the community. And that's what happened here. The owner's argument is really that because of the scope of the CDD, it cannot develop the property consistent with its investment-backed expectations. But the owner's investment-backed expectations are not realistic, given the significance of this site. The council did not create an inordinate burden, and its decision should be upheld. Thank you.
Thank you, counsel. Any more folks want to sign up to be heard? Madam Clerk, how many people are actually signed up? 8. Anybody else? Feel free to jump in and let us know who you are. As I indicated during the beginning of my presentation, I'm going to give at least 5 minutes to those folks who came out today to be heard. Again, everything that you say and do today is on the record. Everything that you say into the microphone will actually be recorded, will be streamed, and will be preserved. Not just for the benefit of me as the special magistrate assigned to the capacity of being here today, but also to the parties, that being the town and the property owner. There are rights given to both parties, both sides. You've heard that from both of the lawyers so far. Let's do this. Let's start with the first speaker if we can. We're going to be civil. We're going to be consistent with the law. We're in a public building. We're going to be civil to each other, and to the extent that I ask that you maintain that civility when you make a presentation, please do so. There's no need to yell or holler, and I appreciate the fact that it's signed. I've seen many signs in my lifetime, and I appreciate the fact that it's discreet. Thank you for doing that. Other than that, please, we can call the first speaker.
First is going to be Anna Curran.
Good morning.
Good morning, Your Honor. Thank you for letting us speak. In around 2000, the town strategized about the crown jewel of Jupiter. They placed a bogus label of slum and blight on our most valuable residential and commercial waterfront property in order to qualify for a CRA, redevelopment and tax control. And I watched developers over the years offer plans for this land, but they could never gain approval because the CRA had no land development regulations as required by 163 within a year of filing the CRA. In 2006, the state of Florida sent Jupiter a mandate that the ODRs be formed for the CRA and that the town become compliant with state law. But finally, they adopted about almost 10 years later the redevelopment overlay and became compliant with law. So I hope you can see that this department has not acted honorably in the past, and it diverts huge sums of tax money away from the majority of the town. Suni Sands was operational when I first moved to Jupiter in the mid-60s. There were 125 mobile homes, 8 apartments, and a large rec building that were crowded on a 10-acre site. Prior to that, a home hotel. The land has had numerous wells and septic tanks with perforated pipe leach fields, sewer, and city water lines. And surely no spiritual guardian could exist due to this land being seriously disturbed, dug up, transversed, and ditched from one end to the other. The town reneged on the development promised to Mr. Modica. They severely burdened his property by restricting his development to one half of the property because our legal processes were taken hostage by out-of-the-area groups and local objectors. Not in my backyard, NIMBY interveners were determined to prevent the development of Suni Sands, and they also supported policies that were inconsistent with our comprehensive plan, our town code, and our ordinances. They gained a lot of political power over our application and appeal process, and thus large portions of Mr. Modica's property now has a regulatory identity of being non-usable preserved lands, crushing his investment-backed expectations. They have made unfounded and unmerited claims. However, no burial site has ever been found on the 11 teeth and a kneecap. In addition, our mayor told the press that the town wants to buy the property and the state's going to help pay for it. But Ruben Acosta, state historical preservation chief, wrote me on August 25, quote, "To the best of our knowledge, the Department of State has no intention of contributing state funds toward the purchase of the Suni Sands property." The town's actions are taking, either by setting aside land as unusable or publicly devaluing the land with a stated desire to purchase. This burden cannot stand its legal plunder. I know firsthand just how the certificate to dig procedure is on Jupiter property, as I was the first owner to seek a certificate to dig in the Jupiter Inlet Village, which effectively returned nothing. However, the youthful archaeologist filed the church midden registration with the state without owner approval or knowledge. These types of studies are costly and only benefit the archaeologists who have a plan for their job security in place. Thank you, Your Honor. And may I submit my records, my written records, and also Mr. Acosta's email stating that the town.
Anything that you brought with you, if you'd like to be made part of the record, the clerk will take it from you, we'll mark it accordingly, and then we'll be able to have it for the record.
Thank you very much.
Thank you, ma'am. Nice to meet you. Pleasure.
Next is going to be Cheryl Snyder.
Thank you, Madam Clerk. Good morning. All right.
Good morning, Your Honor. Cheryl Schneider, Vice President, Jupiter Inlet Foundation. The Jupiter Inlet Foundation, also known as JIF, is a Florida 501c3 nonprofit dedicated to the conservation and preservation of the environmental, historical, and archaeological assets of the Jupiter Inlet area. JIF has been and continues to be a strong supporter of preserving the entire Sunny Sands property. Petitioner contends that allowing development on 60% of the Sunny Sands parcel infringes on its property rights. We disagree. Destruction of over half the property is inconsistent with the town's stated goal of preserving Sunny Sands. The requirement for preservation should not have come as a surprise to petitioner. The mountain of information regarding the archaeological significance of this property was available to the property owner prior to his decision to purchase the land. Even more information is uncovered as petitioner pursued its development plans. The bottom line is that petitioner knew or should have known there would be restrictions and significant hurdles to introducing the first large-scale development on the property in 5,000 years. For example, on November 23rd, 1988, the Jupiter Courier published an editorial calling for Sunny Sands to be marked as an historic site. Around 1990, the portion of the property containing the terminus of the Celestial Railroad was added to the Florida Master Site File. In 1992, following research by the Loxahatchee Historical Society, the Sunny Sands Mitten, the Sunny Sands Staircase, and the Sperry Boathouse were added to the Florida Master Site File. In 2012, the town of Jupiter amended its comprehensive plan to include preservations of these sites as a stated policy goal. It was also well known locally that the entire Sunny Sands property, and not just the state registered sites, held special archaeological significance. This was confirmed by the 286 shovel tests petitioner conducted from 2014 to 2021. These tests uncovered significant archaeological finds, including human remains, dispersed throughout the entire parcel. Despite all this, petitioner has insisted on proceeding with its plans for condos, townhomes, an inn, recreation facilities, and a restaurant. Just believes it is unreasonable to suggest that the town council unlawfully restricted the development rights of petitioner when the detailed record, the expert testimony, and the recommendation of the experts on the Historic Resources Board all support the preservation of the entire 10-acre property. At the end of the day, JIF maintains the town gave away too much and not too little. We urge your honor to deny the petitioner's request and support the town. Thank you.
Thank you, ma'am. If you have any documents of any kind, certainly feel free to leave it with the clerk. Thank you for your time. Appreciate it.
Next, we have MB Hague.
Thank you, ma'am. Good morning.
Good morning, Your Honor.
Nice to meet you.
Nice to meet you too. Thank you for allowing us to speak.
Pleasure.
MB Hague, President, Jupiter Inlet Foundation. The Jupiter Town Council established the Historical Resources Board, also known as HRB, with the responsibility to promote the preservation and conservation of historic and archaeological resources within the town, to advise concerning land development regulations as they relate to the preservation of historic and/or archaeological significance, and to approve and to issue certificates to dig. The board is appointed by council and members must demonstrate to be experts in the field. Adhering to the entire certificate to dig application process during the 3 days of public hearings in 2022, the HRB was provided with a multitude of archaeological remnant evidence from the unknown unregistered areas as well as from the known registered areas, along with extensive input from local archaeologists, the public, and tribal members. The HRB's unanimous conclusion and final determination was the Sunny Sands property proved so overwhelmingly significant that all 10.43 acres of it must be preserved. The board's ruling was an emphatic statement for historic preservation. It was time to stop the lack of sensitivity shown by the town to indigenous cultures that had been living on the land thousands of years before the first Europeans arrived. The message was that Jupiter's leaders have an obligation to do whatever they can to preserve what's left, where it lies, of the town's earliest inhabitants. The board's expert evaluation, advice, and recommendation was sent to the town. Yet in a 3-2 vote, the council failed to uphold the decision of the HRB. I'm proposing to the magistrate, Your Honor, that the town has made a huge mistake. Suni Sands is one of only 3 remaining archaeological sites known to have existed around the Jupiter Inlet. 10 others have been totally destroyed. Only Suni Sands, Du Bois Park, and the Jupiter Inlet outstanding natural area, which is a federally protected property, remain relatively intact. Given context to history, the approximate age of the oldest Native American artifacts at Suni Sands is 1000 BC, compared to the age of the Greek Parthenon, which is 447 BC, the Great Wall of China, 220 BC, and the Colosseum of 70 AD. However, finding shards at Suni Sands of particular fiber-tempered pottery puts into context that people have potentially been living in Jupiter longer than the pyramids of Egypt have stood, which were built from 2700 BC and 1500 BC. Suni Sands has never been subject to major development, unlike any surrounding areas which were slowly excavated and destroyed. Recorded history documents from 1884 to 1899 only several buildings. In the late 1890s, a winter home for a New York financier was constructed on top of the midden. The Celestial Railroad ran from 1889 to 1895, and a boathouse was built in 1906. In 1947, Suni Sands Motor Court Trailer Park opened and remained as that use until the current owner purchased it in 2013. Archaeologists believe that the trailer pads acted as a layer of protection to what lies beneath the surface. Protection is what Suni Sands is due. The town has grievously erred by leaving even 6 acres open to development. Thank you, Your Honor.
Thank you very much. If you have any documents, please feel free to give to the clerk.
I will do.
Thank you very much, and thank you for your time as well. Next up.
Next, we have Vivian McLean.
Quick on those wheels. I have experience.
Good morning.
Good morning, Your Honor. For the record, Vivian McLean Bunce, also Jupiter Inlet Foundation. Thank you for allowing us to speak today. My comments will focus on the enormous impact this proposed development will have on one of the most important and sensitive ecosystems in Jupiter. The Jupiter Inlet is teeming with an abundance of marine life. The estuarine system is vital to the overall economic and environmental health of the region. Seaward of the 961A18 property is an essential marine habitat of seagrass, providing for the propagation of various fish and invertebrate species, and is a host to other marine life and birds. The seagrass bed provides a food source, sanctuary, and nursery for both vulnerable and endangered species, such as manatee, sea turtles, and the small-toothed sawfish. The silt and sand also creates an essential fish habitat utilized by many species during various stages of life, including those of commercial and sport fishing value. 70% of all marine life begins in seagrass beds. This area remains an essential habitat for our local sea life and warrants continued protection. Local recognition of the importance of seagrass resulted in a 2019 strategic initiative by the town of Jupiter and incorporated into the town's strategic plan to promote and protect seagrass in local waters. Residents overwhelmingly supported this effort and continue to do so. The Seagrass Initiative is included in the town's 2022-2024 strategic plan. We at the Jupiter Inlet Foundation are opposed to the applicant's proposed development due to the unavoidable and adverse impact to the adjacent seagrass bed. The Jupiter Inlet Foundation and numerous respected environmental scientists have reached the conclusion that any construction or staging seaweed would cause irreparable damage to seagrass roots, in addition to disturbed silt and sand migration that blocks light necessary for growth. Repeated dredging would be required, similar to the continued maintenance of the Jupiter Inlet, as the natural tidal flow continuously erodes to shallow conditions. The impending use of a boathouse by boat traffic traversing through seagrass and obvious future dredging requests would cause permanent, irreversible damage and ultimately complete loss. What also needs to be understood is the temperament of the community with regards to development, and in particular the Sunny Sands property, a critical component in this case. In 2004, Council approved planning an open space bond referendum for $17 million on the ballot, with the goals of preserving and protecting remaining areas of rare and sensitive natural habitat, and linking existing preserved areas and waterways. Jupiter residents, again, overwhelmingly voted in favor of the bond referendum, which led to the creation of the town's open space program. On March 12, 2019, Jupiter voters approved a referendum authorizing the town to issue up to $20 million in general obligation bonds for the purpose of acquiring land, with focus on purchasing the Sunny Sands property. Jupiter residents have spoken loudly and clearly. Jupiter does not want 6 acres developed. Jupiter does not want 4 acres developed. Jupiter wants the entire Sunny Sands preserved. 3 members of town council voted in direct opposition to what their constituents wanted, which does not bode well for re-election, when their sole job was to consider only what was within the scope of HRB's authority under the town code. The town attorney, after guiding all the hearings, prepared the original HRB order and deemed it to be legally sufficient. In closing, the developer claims he would like to leave a legacy. Quite frankly, this project would be a legacy of concrete, asphalt, grave desecration, and ecosystem collapse. Thank you.
Thank you, ma'am. If you have any documents you want to leave with the clerk, feel free, please.
Thank you.
Thank you, ma'am.
Jessica Neiman.
Good morning.
Hello. Good morning, Your Honor. My name is Jessica Namath, and I am the American Indian and Conservation Chair for the Jupiter Lighthouse chapter of the National Society of the Daughters of the American Revolution, also known as the DAR. The DAR, founded in 1890 and headquartered in Washington, D.C., is a nonprofit, non-political volunteer women's service organization dedicated to promoting patriotism, preserving American history, and securing America's future through better education for children. Its members are comprised of women passionate about historic preservation, and the 50-plus members of the Jupiter Lighthouse chapter here have unanimously voted to have me speak on their behalf, urging the town to preserve the entire parcel of land. This could be for many reasons. A lot of our members have lived here since the 50s and are familiar with not only that historic parcel of land, but many others that they've watched either get demolished or moved to other parts of the state that value historic preservation. Others have been educated by the many presentations that we receive. We have one monthly. And others, like myself too, while researching our genealogy to become members of this, have researched our town history. And through the presentations that we've heard, I have not heard any reference to the countless newspaper articles and photographs that we have from many years ago, much more than 10 years ago, showing the items that were pulled out of the ground there, and talking about all of the skulls that were taken out, or talking about all of the bones. There are countless newspaper articles that talk about our inlet here and the desecration to it prior to any of this development, or prior to anybody owning the land that we're considering right now. And that is a well-known fact. We have a history in this town of not preserving historic sites. We are not familiar, cannot identify exactly where Fort Jupiter was, and that is to the detriment of our youth and to future generations. And those of us at the Daughters of the American Revolution Jupiter Lighthouse chapter would again urge you to make sure that you have done all of the due diligence and have looked far beyond the 10-year history and just what is in the ground, because a lot of things have been taken out of the ground previously when they were doing those pipe diggings or whatever it was, the prior that was discussed just prior to me being up here. Those are all documented in newspaper articles, and they talk about the things that were found very openly because it was not, I guess, frowned upon back then, or it didn't occur to them that they were digging up grave sites. So to that same notion, we are constantly learning and being educated as archaeologists have the opportunity to learn and educate the public about what it seems we should be listening to the Native Americans who have these oral histories are telling us. But again, I think that we need to make sure that due diligence has been done because there is a very well documented history of bones and being taken out of the ground there. So, thank you.
Thank you very much. If you have anything to provide with the clerk, feel free, please. Who's next?
Kimberly Vanderpool,
Good morning, Your Honor.
Good morning.
Kimberly Vanderpool, resident of Jupiter. The certificate to dig is not unreasonable or unfairly burdensome in that it gives the developer too little. In fact, it gives the developer too much. The Historic Resources Board provided sufficient, if not overwhelming, evidence that all 10 acres should be protected. Unfortunately, what we have here is a greedy developer who is willing to go against the wishes of an entire town to build a monstrosity that would be utterly destructive in every way. This is disrespectful to the residents, the town, the environment with one of the last remaining seagrass beds in front of the shoreline, disrespectful to the history of Jupiter, and last but certainly not least, disrespectful to the Native Americans, the original stewards of the land, whose ancestors lie there. I hope the judicial process can be relied upon to determine what is just and what is right. Thank you.
Thank you very much. If you have anything to leave with the clerk, feel free, please. Next up.
Robert Rosa,
Mr. Rosa, good morning.
Tagwe, Didi Robert Rosa, Darin Kirbiate. What I said in my language is, hi, my name is Robert Rosa, and I see you. To see you, to see your breath, to see your spirit, is to recognize you and respect you. And that's all that we have been asking, is for the respect. Now, I heard them claim Shell Midden Mound. Now, that's far from truth, and it's beyond their understanding of what that mound actually was. Not once have they asked any Native Americans. I asked Bob Carr at Brickell if he knew what the Lucayans, because he worked on Preacher's Cave, if he knew their name. He said, yeah, they're Lucayans. They're not. They were Luco Lacayo, which means people of the white sands. So not once, not ever has he spoken with indigenous people, and he goes by a colonial set of rules that were originally imprinted out west in the discovery of Chaco Canyon, where in order to save Albuquerque, that they then made stories up. And their stories carried on. They don't ask us for our stories, but when we do tell them our stories, they have to dig in order to prove that we were right, such as the island out west that it said, oh yeah, that was your island. Now, they also claim that Monica's been here forever, and that single mound was the only mound. That mound stretched from where it is now all the way to the adjacent lot. It was way bigger. And Native Americans don't just build one little mound. Yes, when they built the park, They threw out remains throughout that area because they bulldozed. It's been disturbed. The mound itself has been disturbed. The mound itself has been disturbed recently under Mr. Modica's ownership. They put a camera out there. They had to run the wire through the mound and out. But he doesn't tell you about that. I know about that. They said they found 7 teeth in the patella. Like I said, that burial mound has already been desecrated, and all we ask is for it to stop. They found also a green basalt axe head. Now, Bob Carr isn't up to date with all the research going on. That basalt axe came from the Turks Island, which have a green basalt to it. Therefore, now we're going international. That was a gift to whomever was on that land. And I say whomever because they were mere indigenous. It was colonial people that came here and renamed people. And through colonialism, a lot of us not only lost language, culture, but it wasn't until 1978 that we got the right for our religious freedom by the American Indian movement. Now as well, there's Slockish versus U.S. Department of Transportation. Just recently, under the Religious Freedom Act, RFRA, they won a court case. And it's already been determined that this is a ceremonial place. Now, when I originally came, I agreed with the town historic society that to have 5 acres preserved. Now you're getting greedy. So now we're here. But our elders said, no, we want the whole site preserved. So yes, I did change it. And I did change my tone between the hearings. I'm speaking for Betty Osceola, a proxy as well, so may I have a few more minutes?
Right.
Now, a lot of our stuff, like my elder Betty Osceola has said, it's not privy that we just go about giving our customs away, giving our ceremonies away. We have closed ceremonies because they get stolen. But we don't mind entrusting people with certain facts, culture. Not once has anybody come up to us and asked that. Those middens are burials. And that midden went far away. That's why all these old articles shows the skull here, the skull there. Because as they plowed over, they've done it and discovered it. And not once did the laws protect us. Now we have 872, which is not strong enough. We have NAGPRA law, which they actually just changed the Repatriation Act. So all I'm asking, all I have been asking, which the original decision was to preserve this site. Our elders asked for it. And a lot of people can't be here today because we got so many issues. And Betty is in DC right now trying to protect. This is 2023. Why do we have to keep asking for protection when our government, under treaty, was supposed to protect us, our religious rights and freedoms? This is what I ask. This is what we ask. This is what the people ask, the original inhabitants of what is now America. Let us be one.
Thank you very much. Next speaker. you have any documents to submit, sir, feel free to do so with the clerk. Otherwise, thank you.
Daniel Williams.
Mr. Williams, good morning.
Good morning. Jupiter is a beautiful town. I'm not from here. I'm originally from Stamford, Connecticut, by way of my family. They came from the Caribbean. It's troubling to see how religious freedom is ignored when it comes to indigenous people. It's not ignored when it comes to a mausoleum. It's not ignored when it comes to a cemetery. It's not ignored in any other fashion. And that's the reason why we have federal laws that protect indigenous sites. Now, I have a unique knowledge of this site because I worked in this from ago. Up until this point, I didn't realize that our tribe, my tribe, the Taino, which were thought to be extinct, the first tribe, enslaved by Christopher Columbus in 1492, should not be the last recognized or respected. The green basalt celt that was found by Bob Carr, the misunderstanding of how this was in the Mississippian culture was incorrect. The studies prove now that most of the Mississippian culture had different types of rock and available basalt within their area, and that they did not do any trade with the American bottoms. The green basalt cell, a Lucanian study that just recently came out with regards to green basalt, came from South America and the Caribbean, and it was primarily a ceremonial stone used by the Taino. The Taino originated in the Orinoco Valley of what's modern-day Brazil and Venezuela. People, the Lesser and Greater Antilles, all throughout the entire Caribbean islands and Florida. It's widely known by many universities in Florida, the Smithsonian, as well as other published documentations from other collegiate and academics throughout the entire country, that South Florida tribes were actually related to the Taino, okay? Whether it be the Calusa, the Tequesta, the Ais, the Yega, the Timucua, all of these tribes, and the Hobe, which was more of the cacique of the area. The name, Yega, the tribe that's at Du Bois Park, a few hundred feet from where this midden is. Okay, a few hundred feet, because it was all part, that was the original town. Okay, during persecution of our people, right, from the Spaniards, that turned around and came into the area of what is modern day Jupiter Inlet, also known by Ponce de Leon as Rio de la Cruz, River of the Cross, right, was an inlet port that was used to track Native Americans via canoe. Canoa, a Taino word. Barbacoa, a Taino word. Yega, a Spanish word, form of yegar, to arrive. Ais, the other tribe that they said that was over on the other side, Ai, Spanish means Ai, over there. It's the other tribe that's over there. Jonathan Dickinson, the shipwreck, the Reformation, okay? The little Taina girl named Venus, right? Happened outside the inlet of Jupiter, okay? These people have been coming here for a long time. When Ponce de Leon lost his governorship, okay, he was entitled to pursue the Taino through Bimini, okay? And where did he go to? He went to Jupiter. He went to the Indian River. I have information here which will be available to everybody by the end of today for documentation for download through TainoLegacy.com. You'll be able to see this information. It's all publicly available. I'm not an archaeologist. I know how to read. It's all publicly available. And it's been publicly available for hundreds of years. There's no reason why we should be discussing what is a tabletop midden, a double midden from University of Maine in Orono,
right? Because University of Maine in Oregon Civil Engineering, former dean of that university, was my guest speaker when I created the first beneficial use of automobile scrap tires in civil engineering applications. He was my guest speaker, and he would tell you, you're wrong. Why don't you ask the Indians? The Indians are the ones that'll tell you the truth, right? Really, reality-wise, it's just being known that the Amazon jungle was just forested, right, by the indigenous people. It's all man-made. Why? Because the soils cannot supply the nutrients necessary for certain botanicals to grow. Middens were used, right, to cover and burn the organic materials to create terra preta or terra mullata, which is actually biochar. You have in your record that they found from Bob Carr and all those shovel testings. Hey, there's charred remains here, yes, and pottery and calcium deposits, because that's how you make terra preta. This is not new. This is something that's out there. Okay? Now, we sit there and we wonder whether or not the legacy of Mr. Modica, which, by the way, I would have been the one, I built his restaurants at Love Street. I did the technology build for both of his restaurants during the pandemic. And I gratefully thank him for all the work that was provided by him and his owner's representation, as he was the manager member of his LLC up until recently in May this year. Right? So I'd like to see what kind of corporate games are going to be played on that with that. This is what was going on in the minutes, Mr. Jack. Yeah, that's a ditch witch cutting through that property. Nobody ever told us there was a master site file on this. Nobody actually grabbed the permit to dig because Mr. Modica didn't actually permit it, right? But his owner's reps definitely authorized it and paid for it. And it was paid through Modica's corporations. So do you think he really cared, right, about the indigenous tribe or what's there? And when you guys sit there and say, oh, you guys aren't going to find anything, you're not going to find anything. No. That's like telling us that you're going to fill up a glass of water in the ocean, right, in one spot, and you're not going to find any sharks. It doesn't make sense. Terra preta is made because what happens is after they take the earth, they spread it amongst the entire area in order to grow crops. You're going to find pottery shards. You're going to find bones. You're going to find human and animal bones. You're going to find all of those things on top of the fact that the Celestial Railroad was actually part of the development property and the disturbance to those middens. Okay, up until 20, 30, 40 years ago, American Indians didn't have the ability to sue the government. They didn't have the ability to protect their mounds. They weren't allowed to get onto certain properties because they were persecuted. They were hunted. Okay, it was genocide, the first Holocaust, the Caribbean Holocaust. Okay, that's why in Puerto Rico, 1492, 1493, the Jewish population, which came with Mr. Christopher Columbus, aka Cristobal Colon, aka Salvador Fernandez Zarco, right, brought the actual Jewish people to the islands. That's why Puerto Rico has the largest population of Jews in the entire Caribbean. Okay? We're bound. The same Holocaust, the same story, full circle. We are bound by our legacy, by colonialism. It's time to look at the reality. There are only so many middens and mounds. The mound that's out in the West Coast, in the Southwest, the Calusa, which are related to the Taino, which went back to Cuba, right? When they were persecuted. The Seminoles, I hear all the Seminoles. Mr. Jenkins said, oh, the Seminoles, right? Oh, they okay this. I challenge you, and I challenge any Seminole tribe to stand before this court and say to you that we think it's okay that you take our ceremonial grounds and our ancestors, and you desecrate them, you disrespect them, and you allow development over them. You won't see that from the Seminole tribe of Florida. You will not see that from the Great Miccosukee tribe. You will not see that from the Great Seminole Nation of Oklahoma, and you sure as hell will not see it from the Taino. Okay? We are Seminoles too. Up into the 1700s, when we were persecuted, we assimilated into the Seminole Nation. So you better look at your history books. Because that SCOTUS case is just the beginning of what we're going to do down in Miami and every other place in which colonialism continues, in which development over property that is not just private land, but over ceremonial land that was our private land way before Mr. Modica spent 16 or 17 million. In my opinion, you should just go buy Big Dog next door. Want to put a hotel there? It's a 6-story building. Knock yourself out. Michael, I'm sure, will take a beautiful amount of payment for it. And as far as the CRA is concerned, and the Treasure Coast, right, Regional Protection Agency that recently did a deal with the town in order to do their CRA plan to do that actual boardwalk, right, that river walk that extends to the boathouse that you guys already have planned. This has already been predetermined. Why do you think the mayor's like, I think that we want to build something on there. Yeah, you want to build something on there. You want your river walk. Well, guess what? Your river walk is going to destroy the estuary that's there and prevent the marine life. And I challenge the Coastal Area Management Review Boards of the Department of Environmental Protection from the state and the federal government on that. Okay? These things happen, right? Like the boathouse was destroyed. That's why there's a debris field out in the water.
Mr. Williams, let's wrap up as best we can. I'm not sure.
Long and short, let me tell you the
Thank
truth. Right? Yo soy taíno para que tú lo sepas. Okay? That means I'm taíno, so you know. Okay? We're here, 2018, Hans Schroeder, Maria Nieves Cologne of University of Copenhagen and University of Minnesota at the time, or University of Arizona at the time, right? Arizona State, I believe it was, right? Proved that mitochondrial DNA in that study by Bob Carr and the tooth that was found in Udolo, Bahamas at Preacher's Cave proved once and for all that the Taino are alive. Okay? And that 61% of all modern day Puerto Ricans, 31% of all Cubans are actually have descended of the ancient blood within our bloodline of up to 14%, many of which meet the federal qualification for the blood quantum of over 25%. This man right here, the president of the American Indian Movement, is Taino, and he does meet that qualification. At this time, I will tell you, right, that all you guys thought we were gone. We're not gone. As a matter of fact, we're back. We're not only back, we're the largest living Native American tribe in America, and I prove to you all today, and mark my words, right? We are going to challenge you in the courts. We will challenge you in the courtrooms. We will challenge you in the town halls if you disrespect our people and develop over our ceremonial lands any further. The SCOTUS case has been proven. 15 years, the United States government said, done. We don't want it. Triangle.
Mr. Williams, let's wrap up, please.
Long and short, that's the end of my day. I thank you very much.
Nice to meet you.
I will have this information available to you. I will submit this to you, Mr. Gorin.
Please, thank you very much.
And have a good day.
Nice to meet you. Thank you very much. Other speakers, Madam Clerk?
Caroline Skay.
Thank you. Good morning.
Good morning. I'm Caroline Skay. I'm a local resident photographer, and I've worked in marine protected area management. So first and foremost, I feel so strongly that we have the opportunity and the town of Jupiter has the responsibility to really uphold what the indigenous people are asking for of full protection of this really important site. And I think that obviously that's way more important than any of my personal interests as a resident, but as a resident who spends time in these waters every day and does photograph our wildlife, I'm definitely very concerned and invested in the preservation of the seagrass beds. This area is really unique and holds a lot of endangered species. So just looking at this area and the waterways, it's really important to consider the destruction that could go on. And, you know, this development, you can go all over South Florida and find fancy hotels and, you know, places to shop, but you can't just go in your backyard and find incredible wildlife and endangered species with your your camera every day. And I think it's really important that we consider that value that has more than this $17 million plot of land that maybe can't be developed for more shopping. Thank you.
Thank you very much, ma'am. If you have anything to deliver to the clerk, feel free, please. Anybody else?
Yeah, this is the last one, Terry Grooms.
Thank you, Madam Clerk. Good morning.
Good morning. That's nice to meet you.
Pleasure.
And thanks for coming here on such a blustery, crazy day.
It's kind of weird, but it's okay.
Yeah. Yeah, it was crazy. So I just wanted to say good morning and thank you for allowing us all to speak today regarding the property known as Sunny Sands. You've heard from some amazing, educated, and knowledgeable speakers this morning, and I fully support their comments. I wanted to speak to you today. Sorry, I'm a little nervous.
Relax, it's just me.
I wanted to speak to you today from the perspective of someone who was born and raised in Jupiter, and as a former member of the town's Historic Resources Board. The question, as I understand it, is the property owner believes that the decisions of the town's Historic Resources Board and the subsequent modification to their decision was unreasonably burdensome, and I would say not. As far back as I can remember, it was told to me that the site of Sunny Sands was an ancient one inhabited by Native Americans. Objects found throughout the years give credence to those claims. The fact that the objects dating back to prehistoric times is truly amazing. As you've heard, the site was included in the Florida Master Site File long before the current owner purchased the property, and it cannot be said that the significance was unknown to the purchaser prior to the purchase. The town's Historic Resources Board is bound by certain standards to protect and promote historic resources. As a member of the Historic Resources Board, I took that responsibility seriously. I celebrate the decision made by the current board to protect the entire site and would have made the same decision had I still been sitting. I say that because of the short sentence in our town code that reads, if the board determines that the significant site cannot be reasonably protected and allow development. Objects that have been found throughout the properties, so no one section is more important than the others. How can you protect any portion when the whole site is significant? It was my mandate not to repeat or continue the sins of the past. One by one, we have seen significant signs abandoned, stolen, or forgotten, and then erased and built over. As a community, as a nation, and as humanity, we cannot continue to embrace the mindset that everything is expendable in the name of profit. Because this place, this unique site, contains more history in its 10 acres than we have ever seen before in this town. And this place matters. That concluded my original thoughts, but on a side note, I would like to say that I have some personal first-hand knowledge of the stewardship of this property since Ms. Monica purchased it. In particular, the destruction of the Sperry boathouse. That boathouse was damaged in a hurricane and then left to rot, wrapped in tarps that were, over the years, became frayed and torn, and became an eyesore along the intercoastal there. When they finally decided to take down the boathouse, it was taken down with a backhoe, and it was crushed through, and there were shards of glass, shards of wood, metal, everything you can associate, nails, with the takedown of the building. They had a boom out in the waterway, but that really only served to trap one poor little turtle that later had to be rescued when the tide went out. So the residents, myself and the residents, spent weeks on the beach picking up all the trash that happened when they took down the Sperry boathouse. I didn't see anybody from Team Monica out there cleaning up that mess, or from the excavates, the people who took down the Sperry boathouse. So that part of history was left to rot and was destroyed. I can also tell you that the condition of the property, as Mr. Monica was evicting the residents who lived there were still people who were living on the property, and the condition that they left after they would take up some of the pads in the mobile homes that had been removed was deplorable. There was nails and wood sticking out. The mobile homes themselves were like left open with gaping tarps on them. anybody could be injured. People like to used to walk their dogs through there, and so, you know, pets or people walking there could be injured. I have photographic evidence of all of what I've just said. I have it on my phone, so I can't give it to you today, but I can email it to you. It would be my pleasure. I don't believe that they are good stewards of the property and I don't trust that they will be able to protect the significant parts of the site, so the entire site should be protected. Thank you for your time.
Thank you very much, ma'am. If you would like to submit anything that you suggested, the clerk here will be happy to take it and put it into the record as well.
I just have to email
However
to you
get it
on
out,
my
that's
phone.
fine. That works. Any other speakers, Madam Clerk?
No, Your Honor, that's all.
Thank you. Anybody else show up this morning who would like to be heard that has not yet been heard? Anybody from the public who is here to listen but also need to participate, feel free to sign in now or forever hold your peace, so to speak.
Give it to her.
Okay. Given the opening remarks that were made by me and a review of the statute that I believe is pretty clear, aside from just being a mediator, I get to control the process. And in the context of what the statute authorizes me to do, this part is public, no question about it. We're going to break in a few minutes and repair to another location in the building, where I'm not sure, probably upstairs, if I'm not mistaken. There'll be two separate rooms. Neither party can be in either room at the same time. There may be times, for example, when I speak with the lawyers, I'll be speaking with them potentially in each room separately, but there may be times when I'll call them in separately, and have what's called a sidebar, have a conversation with the lawyers. That's not an uncommon practice in mediation. I know that the city manager from the town will be in the meetings all day today as needed. And the property owner, I believe, is situated somewhere in the building. I've not met him yet, but I'm sure we'll meet him momentarily. I will begin my conversation more than likely with the petition. And you'll find out where you are when I find out where you are in the building. So those members of the public, and again, I thank you for your time and attention this morning. It's appreciated that you would spend your time to be here in this process. You are a part of that process. The statute contemplates that. It actually requires it to the extent that you would seek access to the process. I commend you for doing so. Public comment is always very important, not just the mayors and commissioners, but also the people like myself who are hearing for the first time some of the live testimony which you provided in the statements you've given this morning. So for that purpose, I say thank you. On behalf of both the petitioner and the respondent, the town and the property owner. So in the next number of hours, there will be nothing to tell you except to suggest that I'm going to be meeting in private with both parties. To that extent, you will not have access to those discussions, and again, nor will either party, if that's the case. There actually may be times during mediation where both parties may actually meet and have a brief discussion. That's possible in the mediation process. At this point, it's now approximately 11:38. I appreciate you being timely and thoughtful in your presentations this morning. We're going to break, and we'll hopefully find out where we're going to be for the next number of hours somewhere in the building. Mr. Counsel.
Thank you, Mr. McGoran. I was informed this morning that the property owner has invited a number of consultants.
Okay.
This is a mediation. I do not know if we are traveling under the court rule in terms of confidentiality regarding this mediation, but I am concerned with the number of individuals that have been invited to participate, since you will be sharing confidential information that the town authorizes you to share with the property owner. I think first order of business needs to be to decide whether the consultants, I understand there's a Mr. Carr, archaeologist, there's a architect, there's a planner. I'm not sure that we're getting into the details of a site plan today, but I am concerned that those individuals might be privy to some shared thoughts between the town and the property owner in terms of how this particular action might be settled.
Okay. Council would like to be heard as well. Alice?
Thank you, Mr. Gorin, Mr. Baird. More than happy to segregate them out of the discussions with Mr. Gorin to the extent that's necessary. We had brought them in case issues did come up where we would need the advice of consultants beyond our individual expertise. but happy to segregate them out for those discussions if that would be helpful to the town.
Mr. Baird? I'm not sure where they will be segregated. We had planned for
In the lobby.
two camps.
Correct.
Perhaps Mr. Jeck's office would be an appropriate place for them to be segregated, and they can contact them when they need them or if they need them.
For the record, I'm going to concur with your argument with regard to segregation, also separation. And what that means to those of the public that are here is I'm meeting with the town manager and the town attorney. I'm meeting with the lawyers on behalf of the property owner and the owner. To the extent that I have the need to consult with any third-party consultant that may be available, I will seek that guidance. But there is a privilege involved. What that means is that it's a sacrosanct process. And to that extent, it's privileged and confidential. And again, as Mr. Baird aptly placed the conversation, what I discuss in one room is not discussed in the other room unless there is a specific consent to do so. I've been in multiple mediations in my lifetime, and I don't have free license to simply open up a door and talk about things that have not been directed that I talk about or authorized to talk about. So you should know going into the process and listening to the process, that's not how it's done. Maybe some mediators do it, but I'm not, and I don't, and I will not approach it that way. So that being said, we'll segregate the parties. We'll make sure that the same parties that were initially engaged to be in the rooms will be there. And I'm prepared to recess the public session and repair to the first session with the petitioner's counsel and the owner. Okay? I'm going to follow you all wherever you are. Thank you again. And yes, ma'am, what you got?
I just wanted to ask if you guys are gonna be a couple of hours, is there a way for us to be notified when you're gonna come back?
What I can, again, here's what I'd like to suggest perhaps. You can stay in this room as far as I know. I don't have a key to the door, so to the extent that it's a public building and you can at least sit here, like I said in my opening presentation, I could be in the room with some folks for 5 minutes or 5 hours. I've done this before, and from that perspective, I can't predict how long that might take. So if I can at least perhaps on a periodic basis let you know that where we are, not informationally, but just time-wise. I'd be happy to try to do that, or at least let the clerk know.
Okay, thank you.
Okay, thank you as well. There you go. Going to recess, and nice to see you all, nice to meet you all. Thank you.